In this lesson, I'm going to provide you with instructions on how to serve your spouse with divorce documents. So, a copy of the filed divorce petition FL100 and court summons FL110 should be served along with financial disclosures on the respondent. In addition, the petitioner must provide the respondent with a blank FL120 form, which is the response. The respondent will have 30 days to respond to the divorce petition. Keep in mind that if you haven't completed financial disclosures, it's okay. Go ahead and serve the respondent with the filed divorce petition and court summons. You can subsequently serve the respondent with your financial disclosures within 60 days from the time you filed your divorce petition with the court. Now, a neutral third party must serve the documents on the respondent. The process server, that neutral third party, must be at least 18 years old and not a party to the lawsuit. This means you cannot serve your spouse with the divorce documents personally. Once they have provided service of process to your spouse, they must complete and sign FL115 and file it with the court to confirm the respondent was provided notice of the pending divorce. Failing to serve your spouse may result in your petition being withdrawn by the court. So, the first step on how to serve your spouse with divorce document includes obtaining a copy of the filed court documents you submitted to the court. After you file your documents with the court, you'll receive 2 file copies. One copy is for your records, and the other copy is to be provided to the respondent. Applicable filed local forms, FL100 and FL110, must be served on the respondent. A copy of FL120 must also be served. Serve the filed FL105 form if you have children, along with the child custody and visitation application attachment, FL311, as well. Step 2 requires you to have a person over the age of 18 serve the documents on the respondent. Alternatively, you can hire the county sheriff or a professional process server to provide this service on your behalf. The server can select a method to serve the documents on the respondent. California courts accept personal service and service by mail with a notice and acknowledgement and receipt form, which is FL117. Personal service means the respondent was personally served. The documents were hand-delivered. Service by mail occurs when the server mails the documents to the respondent's home address. Your spouse must sign FL117 when providing service by mail. Documents must be served personally if the respondent refuses to accept documents by mail. Step 3. The person who completed the service of process again must complete form FL115 and submit the signed original to the court for filing. Before the signed FL115 is submitted to the court, however, make 2 copies of the original document and send 1 copy to the respondent and keep 1 copy for your records. Both parties will have to file financial disclosures and the final judgment documents on each other if the divorce proceeds as an uncontested matter. You're going to follow the same instructions here regarding serving the other party using a neutral third party when serving your final divorce judgment documents. If you have any questions regarding serving your spouse, contact us at info@sdesquire.com or send us a message in your user account portal. Please proceed to the next lesson.